Hi, I'm Reed Bloodworth, attorney in Orlando, Florida. I practice business litigation, estate and trust litigation. Today, I wanted to talk a little bit about estate and trust litigation and a scenario that may help explain it. The scenario is this. A gentleman served in the military for 40 years. After retiring from the military, he moved to Florida and worked for the state of Florida for additional 10 years. At this time, he was married and had 3 children. At this point in time in his life, the children were named equal recipients of his various retirement plans, be it military, state of Florida insurance policies. The wife was the primary beneficiary under this gentleman's will. Later in life, this gentleman gets divorced. After getting divorced, he changes a number of his recipients of his retirement plans, insurance policies, and eventually his will. What happens is this. The gentleman got sick. He got cancer. And late in his life, as he is on his deathbed, his will and the recipients of his various retirement plans is changed. The previous will and the previous recipients of his various retirement plans were his now ex-wife and his 3 children, and they were to receive these items in equal shares. Shortly before this gentleman dies, he's heavily medicated. He doesn't comprehend things well. He's in a lot of pain. And his will is changed, and the beneficiaries to the various retirement plans and insurance policies are changed. And they are changed so that the new wife is the primary beneficiary under the will, and the new wife and one of the children is the primary beneficiary under the other various documents, the retirement plan from the military, retirement plan from the state, insurance policies. The ex-wife and the 2 children that were not included in any of this gentleman's will or other documents that would have left assets to them became aware of this after the funeral. However, at that time, they didn't do anything. They were served with a notice of administration of the estate. That means the will was admitted to the court to open probate. Documents were then served on these individuals. And what that does is starts a statute of limitations running if you want to contest anything under the will. Unfortunately, the ex-wife and the 2 children who did not receive anything failed to act. And as a result of that, the statute of limitations ran. They were unable to contest this will. However, had they consulted a trust and estates litigation attorney, they would have discovered they had grounds to challenge this will and challenge the change to the beneficiary of the various retirement plans and insurance policies. Because this gentleman was so ill and so heavily medicated at the time these changes took place, the ex-wife and the children would have had grounds to bring a cause of action against the new wife and the 1 son. The cause of action, the best cause of action likely in that scenario, would be a lack of capacity. may also be accompanied by an undue influence claim and a claim for tortious interference with a testamentary expectancy. I say the best claim is the lack of capacity because this gentleman was heavily medicated, was dying of cancer. This was something that was literally done on his deathbed. He did not understand things well. He was in a lot of pain. And under these types of scenarios, the law is that person likely did not have the mental capacity to understand what it was he was doing. To execute a will or a trust in the state of Florida, you have to have the mental wherewithal to understand what it is you are passing on to others. You need to know what you own, what you have the ability to control, and then disperse that to your chosen beneficiaries. Someone in this gentleman's situation, dying of cancer, on his deathbed, very heavily medicated, very high probability he did not have that mental capacity. Again, this is just a situation where, had the family acted sooner, they may have had a very different outcome in terms of what they received from the decedent. Unfortunately, it didn't happen. It's something that it troubles me, and I like to help people, and I would like that scenario not to happen to anyone else. So again, my name is Reed Bloodworth. I'm an attorney in Orlando, Florida. Give me a call. Let's talk about what happened to you.